Hi, this is Andrew Drastic Jr., and I'm making a short video again today based on summaries of my public policy and public interest research that is for the involvement of the government of the United States in cooperation with the government of Japan. The information is relative to all volunteer lobbying activities that have proposals for research funding. The right of the audience in both jurisdictions of the United States and Japan can address this with academics and the institution of higher education. There is a key statement that the public policy of Japan enjoins the United States and Japan, and I will read that. It's in the description. Two main goals of policy with the government of Japan and the Ministry of Health, Labor, and Welfare Agency was announced in 2014. The strategy of SAKIGAKE. Some of the main points were to address research and development, the drug repositioning, regulatory science, and the scheme development for unapproved drugs. In 2015, Japan is serving as chair of the International Conference on Harmonization of Technical Requirements for Registration of Pharmaceuticals for Human Use, as it is stated in their policy statement from the International Pharmacological Regulatory Harmonization Strategy Regulatory Science Initiative, which was published in 2015. Japan will take a central role in the activities of the International Coalition of Medicines Regulatory Authorities and in formulation of the respective strategies. What this means is for the United States and Japan to have discussed why they would enjoin with certain methodologies and certain schemes that are for the attestation of research projects so that they may be involved by the government's approval and receive federal funding, and also have the approval by the academic institution of higher education that the proposal for research funding would be given some involvement by the persons who make those approvals. This draws attention to a letter that I wrote to a specific institution that makes some concern for their privacy and a social network services such as Google, Twitter, Facebook, but they need to be mentioned, I believe, in this regard because I'm not writing them a letter and they have a public policy that supports this intention. The Office of Research and Innovation of the Tokyo Institute of Technology, Public Relations Division, and Industrial Cooperation Planning Group. Their policy is in the bottom part of the description for the use of social network services, published June 1st, 2022. It may be applicable to the YouTube audience and how they conduct their activities. Tokyo Institute of Technology Privacy Policy, which is stated also from their website. Their institution of higher education in Japan has certain endeavors and public proposals that they list their academics involving the rights of what the Ministry of Health, Labor, and Welfare as an agency and the government of Japan would promote and provide. In those regards, for the concerns of what is a contemporary issue that the government of Japan does not permit, but is part of human health and the rights of therapeutic products involving regenerative and cellular therapy products. In the United States, a very common over-the-counter drug program that involves sample merchandise. I have a couple samples of them here. One is dihydroepiandrosterone, and it's sold commonly over the counter. Another one is called pregnenolone, Pregnenolone, if I'm not pronouncing that correctly. But these sample merchandise that are available with the over-the-counter drug program are already approved by the Food and Drug Administration. In Japan, they would be a question of the law of Japan in the jurisdiction of customs, that the customs law, and as it's noted in citation in the bottom part of this video, again, for securing quality, efficacy, and safety of pharmaceutical, medical devices, regenerative and cellular therapy products, and gene therapy products of the cosmetic law. It's listed currently as prohibited for only the rights of persons to receive self-medication by prescription only. The Ministry of Health, Labor and Welfare Pharmaceuticals ingredient name list publicly. That hyperlink is also in the description. As a reference to this, as to how the United States Food and Drug Administration and the Ministry of Health, Labor and Welfare as agencies would comply, involving research and development and the regulatory review of schemes that are for the attestation. One important jurisdictional concern involves the right of the judiciary in the United States, that the import laws would involve the Customs Court Act of 1980. And that is a public law that is researched from Justia. The regards of how it would be underwritten by the Customs Court, commonly the import-export of the legal authority, that the Export-Import Bank of the United States reviews the sureties that are involved by how institutions of higher education may have business of interested parties in logistical supply chain through the pharmaceutical industry, that they're qualified to underwrite with the fiduciary capacity and duty of care for the rights of the research. The United States International Trade Commission, in these regards, with the rights of the industrial interested parties that supply the raw materials that are in mutual cooperation, the confidential business information and the submitter that would be involved by the interested parties has some direct significance, that they are part of what the proposal and fund grant making would be for the intellectual property rights in future concerns and underwriting of the intellectual property rights for the pharmaceutical industry and branding in Japan. In the regards of attestation, the International Standards Organization recently, last year, publicly made a very good document called Building Trust, the Conformity Assessment Toolbox. I recommend that any party who is interested in these activities read the document. The hyperlink is noted. And the development scheme documents a guidance for International Standards Organization technical committees from the International Standards Organization's Central Secretariat in Geneva, Switzerland. They published a document in 2019. I've been following the International Standards Organization for about 4 years, trying to get some work together as to how it could benefit the rights of the institution of higher education and persons who wanted to be involved with interested parties that they would like to enjoin by the underwriting and make funding proposals. So I have prepared 2 working paper thesis proposals that are also in the description. One titled International Standard Conformity When the Customer Satisfaction Code of Conduct Applies, Relevance and Effectiveness, July 12, 2021. And a second one, System Science and Methodology Analysis of Contemporary Model, that was published in September 9th, 2021. They're both available by the Social Science Research Network. So I am hoping that the government of Japan and the government of the United States can take advantage of my goodwill in this volunteer lobbying activity and proposal for research funding. I actually did not intend to go to Japan, but I am currently making plans to try to address this similar activity with business organizations and underwriting. So if that becomes true in the next 2 or 3 months, you may actually see me in Japan, and try to help me if you can with my somewhat basic Japanese and my willingness to learn more and cooperate with the government of Japan and the Japanese people. So if that does become true, we will meet then and discuss these types of issues and have what we can mutually, and possibly form legal agreements. That is what I'd like to disclose today. And if any party would like to send an email, of course, I believe the email is publicly available. I receive emails from parties that are sent emails in some regards for commercial purposes, but there could be some concern with either YouTube or how the electronic mail service is being used by VPN litigation or by jurisdictional actors of judicial immunity that for the rights of intellectual property, as to how this type of public video would be involved by manufacturing intellectual property rights with the electronic mail service. According to what I've read in Japanese law, there shouldn't be a problem. So to send an email back, I've received some emails from Japan, and I assume that other jurisdictions can also as well. My name is Andrew Stephen Drastic Jr., and I look forward to doing some good work with people who are willing to cooperate. Thank you, and have a good day.